Ladies and gentlemen, thank you.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I'm your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And I'm going to point out some things in this video that should open some people's eyes to the reality of the situation that we've been talking about for a long time. But it's interesting. When the PDS, the POV derangement syndrome, hits home, I believe it blocks people from seeing the things that they need to see. And instead, it prompts them to lash out. I read this post yesterday, and I wanted to make sure that I read it to everybody and make sure it's known what POV deals with on a daily basis. And I want to write this one in stone, so when the things that happen in this case that I'm predicting happens, then they can go back and reflect on these thoughts.
I'm putting this out there right now because this is what I feel. If anyone at this stage is trying to discredit what Dr. Brent Tevye is saying or trying to downplay his concerns around Ann Taylor, then they are doing it for one of the three reasons. 1. They are guilters, posing as people who believe Bryan is innocent because there is monetary benefit in it for them. 2. They are missing the points being made and not fully understanding the points being raised. 3. They are simply as dumb as a box of frogs. Ribbit. I trust Tevye 100%. Sadly, I do not trust Ann Taylor, a state-appointed attorney whose job is to save the state money by trial avoidance and getting plea deals accepted. No different than her counterpart, Bill Thompson, an ex-UOI student herself who appeared to be weak, appeared to be out of her depth, and by her own admission was not prepared for trial. Yet, days later, convinced Bryan not only to accept a plea deal, but to state he was happy with his counsel. Would you be happy with your counsel if just days earlier they admitted to not being prepared for trial, having known they had taken on another capital case beside yours? Wake up!
So according to this guy, the decision is clear. We either put all of our trust in former FBI agent and former NBC analyst, yeah, that's right, Dateline NBC, Christopher Whitcomb, and ousted defense expert Brent Tevye, or Bryan Kohberger's defense team. Now, they clearly just want to call it Ann Taylor and bash Ann Taylor and have you really don't like Ann Taylor and say she did a terrible job. But what they're really saying is Bryan Kohberger's defense team, because forever we couldn't even verify if Bryan Kohberger's defense team still represented him. But thanks to all of the new hoopla, we now have definitive proof that not only is Ann Taylor still Bryan Kohberger's attorney, but so is Elisa Massoth and Bicka Barlow. Now, many people out there could make the case that Ann Taylor and Elisa Massoth, because they were court-appointed public defenders, would still represent Bryan Kohberger at this point because of other issues that may come up, such as we've dealt with restitution and the unsealing of sealed court records. But that argument cannot be made for a pro bono out-of-state attorney who got on the case pro hoc vice, and there's absolutely no reason for Bicka Barlow to still be representing Bryan Kohberger at this point if there is nothing happening and they're sealing his fate and these guys are coming to the rescue like that guy just said in his post. So let me remind you of this, now that we have true verification that all three of these attorneys still represent Bryan Kohberger in the state versus Bryan Kohberger. Because in their press release to tell Tevye to shut up, it actually is signed by his three current attorneys, Ann Taylor, Elisa Massoth, and the attorney that brought Tevye onto the case, his so-called friend, Bicka Barlow, signed that thing too. So when those people make those statements, they're saying all three of these ladies would be the ones to be discredited versus those other people. And when you really dive into it, though, I think the Bicka Barlow situation should tell you everything you need to know. Let's ask AI what AI thinks, shall we? So I asked AI, I said, in Idaho law, once a defendant takes a plea and is sentenced, is it typical for his attorneys to still represent him 9 months after sentencing? And if so, why? And their answer is no, it is not typical for a defendant's original trial attorneys to still represent them 9 months after sentencing following a plea deal. Under Idaho law, once a final judgment is entered and the standard post-trial motion windows close, the trial attorney's representation automatically terminates unless specific legal actions are actively underway. If the attorneys are still listed on the court record or actively representing the defendant 9 months later, it is usually due to one of the following reasons. An active direct appeal is underway. While a guilty plea severely limits the right to appeal, defendants can still file an appeal under certain specific circumstances, such as a conditional plea reserving the right to appeal a pretrial motion or a claim of an illegal excessive sentence. The timeline. An appeal must be filed within 42 days of sentencing in Idaho. Why 9 months? The appellate process is lengthy. 9 months post-sentencing is right in the middle of preparing records, transcripts, and submitting appellate briefs. If the original trial attorney did not withdraw, or if they handle appeals, they will remain on record. Post-conviction relief proceedings. If the defendant is trying to challenge the plea itself, usually by claiming ineffective assistance of counsel, a civil lawsuit is filed against the state under the Uniform Post-Conviction Procedures Act. Idaho law allows up to 1 year from the final judgment to file a post-conviction relief petition. Why 9 months? At 9 months, an attorney may be actively building the PCR case, gathering new evidence, or responding to the state's motions to dismiss. If the claim is ineffective assistance, the defendant will have a new attorney or public defender, not the original trial lawyer. So that should tell us if they're still representing him, the claim is not going to be ineffective assistance of counsel. It's going to be something else. Sentence modification, Rule 35 motion. Under Idaho Criminal Rule 35, a defendant can request that the court reduce or modify their sentence. Rule 35 motions based on excessive sentence and new mitigating information must be filed within 120 days of sentencing. Why 9 months? While the motion must be filed within 120 days, Idaho courts take several months to schedule a hearing. We know that didn't happen, so we can cross some of this off. Probation or restitution disputes. If the plea agreement included supervised probation or deferred restitution order, the case remains active under court's jurisdictions. This is what the guilters will say. That's why Ann Taylor and team is still on there, because of restitution disputes. Well, that would make sense for them, but not Bicka Barlow. Administrative delay, failure to formally withdraw. In many cases, the representation 9 months later is purely administration. They just failed to file a motion to withdraw. So it explains some things and other things it doesn't. But then we have to add in this caveat. I said it could be argued that this court-appointed public defenders are still part of the case due to ongoing issues related to restitution and unsealing of sealed court records. However, a pro bono attorney from out of state still representing the client at this stage seems highly unlikely unless legal action is expected. Agreed? Yes, entirely agreed. Your logic is completely sound. Thank you there, AI. While public defenders are systematically bound to handle routine, localized cleanup matters like ongoing restitution disputes or unsealing records, a pro bono attorney from out of state staying actively attached to a case 9 months post-sentencing is highly unusual. An out-of-state attorney represents a massive expenditure of uncompensated time, travel, and resources. They do not stay on a closed case out of inertia or administrative oversight. Under Idaho law, standard legal practice, their continued presence almost certainly points to one of three highly calculated legal strategies. Number one, preparation for an impending post-conviction claim. The most probable reason for an out-of-state pro bono attorney to stick around is that they are preparing a petition for post-conviction relief. The strategy in Idaho post-conviction relief is technically a civil lawsuit challenging the conviction itself, often based on constitutional violations, new evidence, or ineffective assistance of the public defenders. Considering the public defenders are still on the case along with her, we can cross that one out. But what would the new evidence that they bring be? Well, the new evidence will be the packet for the investigation that the special prosecutor conducted into the leak. That is going to be their new evidence, y'all. The timeline, the absolute deadline to file post-conviction relief in Idaho is 1 year from the entry of the judgment. At 9 months post-sentencing, the clock is ticking loudly. The attorney is likely using this window to review the unsealed records you mentioned, build the petition, and prep the filing for the 12-month statute of limitation expires. And that'll be on September 3rd, y'all. A significant federal habeas corpus strategy. If the out-of-state attorney specializes in civil rights, constitutional law, or wrongful convictions like Bicka Barlow does, they may be laying the groundwork to take the case into federal court system via a habeas corpus petition. The catch, to get into federal court, the defendant must first exhaust all state remedies, which means they got to file PCR in the state before they can file habeas corpus. High stakes appellate or media aligned advocacy. Out-of-state pro bono counsel, such as those from the Innocent Project, Civil Liberties Group, or specialized nonprofits, generally only take cases that have a broader systematic impacts, high publicity, or egregious injustices. They're likely not interested in the day-to-day restitution arguments. Rather, they're focused on the unsealing of the court records. Fighting to unseal records at this stage strongly indicates they believe there is hidden, potentially exculpatory evidence, procedural misconduct that will allow them to legally blow the case back open. That will allow them to legally blow the case back open. Imagine that. Bottom line, an out-of-state pro bono lawyer is a specialist. If they've not withdrawn 9 months later, they're not just watching from the sidelines. They're actively treating this as a live, ongoing battlefield. They're almost certainly waiting for the final resolution of those sealed records to launch a major, coordinated legal strike to vacate or alter the conviction. Are you tracking this case through the Idaho public court docket, or are you trying to anticipate when the next filing will drop? If you can share what kind of organization the out-of-state attorney belongs to, I can give you a better idea of their likely end game. We already know all that. We already know the reason for everything is the special prosecutor's investigation. So I will gladly take all that criticism right now and be called names, because when it does file and the truth is revealed, well, you know, old Pav's going to double back and point out those haters and what they hated on. Attack my credibility, you will have none in the end. Now, I've heard many people out there say, but Pav, how could you say that, they did all they could if they sent Bryan Kohberger to prison? I mean, is an attorney sending somebody to prison, is that a good job? And I would say, well, no, that isn't a good job. But then again, I can remember all the circumstances around things before that deal was made. And I purposefully believe that the deal was made with what's going to happen now in mind, maybe even pre-agreed upon with parties such as Josh Hurwitz. And I'll say why I say that. Because I remember the change of venue hearing in this case where the defense had an expert poll the media, poll actual people in the area. And the answers to the poll was pretty clear. 90% of the population of the entire state of Idaho had an opinion already on the guilt of Bryan Kohberger. 90% of people polled agreed that Bryan Kohberger was likely guilty. They knew that before the change of plea hearing. Then, just prior to the trial, we have the Dateline leak, where Dateline does an episode sealing Bryan's fate in any possible jury pool. Now, we know now that when they went to trial, they would have shown all the evidence that proved that Bryan Kohberger was not guilty. Yet, with a poisoned jury pool on the front end, even the evidence that they would have shown, you can bet, would have fallen short if the trial would have happened at that time. So a strategy to push things off for a year was twofold. One, to wait for the leaker, to get everything prepared for trial, and in my humble opinion, to allow things to happen that we know happened, like law enforcement coming out and making statements, absolutely annihilating all of the mainstream media's BS talking points that they had said for 2.5 years. See, those no longer exist, such as Bryan putting his trash in the neighbor's trash can and all the other things, following the victims online. That's all now out into the public. So when this does go to trial, at least the advantage the state had of the public already making a decision would be diminished for at least for a little bit. So then there's the fact that Kohberger did go to prison, yet they told us he's in J block, and he's been there in J block being tormented. Yet I remember all of the 18207 hearings between the defense team and Mr. AK himself, Josh Hurwitz, and what 18207 means. 18207 means that Bryan Kohberger would likely not be incarcerated like a normal prisoner would be. He would be in some type of medical cell. And that's why I think the leak of Bryan Kohberger in prison was such a big deal, because it didn't show him in a normal cell. It showed him in a medical cell. And you can go back to all the videos I did where I talked about the 18207 and all that went down around that. And then when I seen them release this video of Kohberger in this particular cell, I thought to myself, well, there's your 18207. He's not in a regular cell on J block. He's in a very large medical cell, and he's going to be in there comfortably waiting for this moment in time right now, if I'm correct. If I'm incorrect, then I'm incorrect. I don't think I am. I'll let you decide, and you decide who you want to follow and support.